courts have signed off on all of this. Courts are all over this. Plate reader hits show up in charging documents, they show up at trial, and judges look at them. That's true, and I'm going to make it worse for myself before I answer it. 12,892 of the searches in the file I'm about to show you are filed under the category this system calls wanted person, arrest warrant, fugitive. A judge signed those warrants. A real judge. And I'm not waving that off. A warrant to arrest a man is not permission to search where every car in a city has been. When a court signs off on something like that, it looks like this. May 2019, somebody robs the Call Federal Credit Union in Midlothian, Virginia, and walks out with 195 grand. Police take a warrant to Google and draw a circle around the bank, 150 meters out. Google hands back a list of whose phones were inside the circle. One of them belonged to Okello Chatry. That fight took 7 years. The full Fourth Circuit heard it, split evenly on whether it was even a search, and affirmed in one sentence without deciding it. June 29th of this year, the Supreme Court answered 6-3, it was a search. Everything Carpenter relied on applies as well or better to the police's accessing of Google's location history data. Two things in this case are cutting against my argument here, and I'm going to point them out too. Chatry is Google's database. Nobody up there has said one word about a camera on a pole. And he didn't win anything you'd notice. Vacated and sent back. No evidence thrown out, nobody walked. The bigger one is older than all of it, and it's from the case this whole series started on. Knotts, 1983, page 281. A person traveling in an automobile on public thoroughfares has no reasonable expectation of privacy in his movements from one place to another. That's a court signing off on cars on roads. It's the strongest argument against this, and I can't hide that. So look at the file. The search log out of the Flock system in Kalamazoo, Michigan. Every search anybody ran on it for 6 months, they told me no the first time, and I appealed. More than 115,000 searches. There is no judge in this file. There's no field for one. Who searched, when, what they typed, why they said they did it, how many networks it reached. That's the file. One column in it records a decision. It's called moderation. On 115,963 of these searches, it's blank. On 54 of them, there's one word sitting in it. Allow. Wow. Those 54 are the searches where somebody typed a sentence describing a car instead of typing a plate. So the software read the sentences and said yes. The file doesn't record anybody checking the other 115,963. That's the closest thing to a review in the whole thing, and it happened 54 times. My position is that a search this size ought to be asked for out loud, in front of somebody who can say no. The courts did check the nearest thing to this. They checked Google's database in June, and they called it a search. Nobody has checked this one. I'm still not a lawyer, and the Supreme Court has never said one word about Skynet. When it does, I'll tell you about it. Drop an email at magneticnorse.com, and the Norse letter will keep you posted. Next time somebody says the courts have signed off on all this, agree with them. Then ask them which judge. Or just send them this video. Magnetic Norse!